A very good day to Madam and my classmates. My name is Wei Hong. Today, we will discuss the 3 case laws that related to the source of international law. Without further ado, let us begin with the first case of the day.
Alright, good day to Dr. Ratnalia and fellow friends. My name is Poppy Ling. Now I would like to take everyone to have a look at the facts of the Prakriti Habana, the Lola in 1900. The Prakriti Habana, the Lola in 1900, was a landmark decision of United States Supreme Court concerning the applicability and recognition of international law by the United States. Parties involved that are said to be, in this case, are Cuba under Spanish rule, which the Prakriti Habana and Lola from, and the United States. Back in 1898, the United States declared war with Spain, established a blockade on the northern coast of Cuba, and imposed spoils of war during the Spanish War, which known as the American War. Two fishing boats, the Prakriti Habana and the Lola, sailed in and out of Havana under the Spanish flag. A fishing vessel often engaged in fishing off the coast of Cuba. On the way back to Havana, they were captured by a United States gunboat. Inside the boat was only fresh fish caught by the crew. The owners did not know of the war until they were stopped by a United States field squadron. No criminal or illegal materials such as weapons were found on the fishermen, nor did they make any attempt to resist their arrest after learning of the existence of the blockade. Thereafter, the United States District Court ruled that the two fishing boats and their cargo were condemned as war crimes. On appeal, the United States government argues that it complied with international law. As president for the executive branch of the state, through its military commanders, to have discretionary authority over whether to exempt fishing vessels as war trophies. Notably, the government has never disputed that it must comply with international law. Both parties in this case were invoking customary international law, which is the prevailing and long-running practices and norms observed and accepted by most countries as obligations, but differ as to what it permitted concerning prices. The action was taken from the owners of two fishing vessels was their appeal to America's Supreme Court. They argued that both the customary international law and the writings of leading international scholars recognized an exemption from dinner in wartime of coastal fishing vessels. The issue that had arisen from this case is, should coastal fishing vessels with their cargoes and crews be excluded from prices of war?
Good day, Doctor. I'm Lim Jiahui with the metric number 278342. The Supreme Court held in this case that it said yes. By an ancient usage among civilized nations beginning centuries ago and gradually ripening into a rule of international law, coast fishing vessels pursuing their vocation of catching and bringing in fresh fish have been recognized as them with their cargoes and crews from capture as prizes of war. This doctrine has been familiar to the United States from the time of War of Independence and have been recognized explicitly by French and British governments. International law are part of American law and must be ascertained and administered by the courts of justice of appropriate jurisdictions, as often as questions of right depending upon it are duly presented for their determination. With regard to this case, the United States Supreme Court found that resort must be had to the customs and usage of civilized nations because there were no treaties and no contrary executive or legislative acts or judicial decisions. So the court examined some states including British, French and Prussia and examined their court decisions regarding this type of case. The court pointed out that there were several states that practiced a custom whereby the commercial fishing vessels were exempted from being captured as prize of war. This practice was considered customary in nature because it was observed to be followed over a long period of time. The repetition of the practice made commercial fishing vessels exempt. It is an established rule of international law that coastal fishing vessels with their equipment and supplies, cargoes and crews, armed and honestly pursuing their peaceful calling of catching and bringing in fish are exempt from capture as prizes of war. Thus, the Supreme Court declared that the capture of both vessels, which is the Prakriti Habana and the Lola, was unlawful and the decree of the District Court was reversed. That's all from me, thank you.
Besides that, the contribution of this case is the United States Supreme Court in the case of the Prakriti Habana, the Lola in 1900 took that the international customary law of maritime law as a part of its domestic law, and the international customary law also came from its domestic law, and lastly, the international law was unified and universal in the maritime law.
Wow, what a fantastic presentations by Jiahui and Pei Ling. I believe that everyone will understand how the first case contribute to the source of international law. Now, let us proceed to the second case law, which is the Barcelona Tractions Light and Power Limited Company case. The Barcelona Traction Light and Power Limited Company, BTLP, was founded in Canada, with its HQ in Toronto, to manufacture and supply electric power in Spain. The Spanish government denied the Belgian government's claim that Belgians predominantly held the Barcelona Traction's share capital after World War I. Barcelona Traction survived in the Spanish Civil War mostly undamaged and remained profitable. Due to foreign investors, the company issued multiple series of sterling bonds. However, to aid Spain's economic recovery post-Civil War, the government banned the outflow of foreign funds. On 12 February 1948, the court declared that the BTLP and its two subsidiaries were bankrupt for failing to pay the bond interest. Belgium sought compensations for losses suffered by the Belgian stockholders to defend its citizens and their interests. The Belgian government brought its first request against the Spanish government in 1958 after failing the first round of negotiation. Before that, Belgium, Canada, the United Kingdom, and the United States had gone through a round of diplomatic negotiations. After the negotiations, the interpositions of the Canadian government ceased entirely in 1955. To facilitate negotiations between representatives of private interests, Belgium's government issued a cease and desist notice in 1961. The case was then removed from the Cour Généraliste. The Belgian government submitted to the court a new application on 19 June 1962 after the negotiations failed. The Spanish government also raised 4 preliminary objections to these applications in 1963.
Good day, Doctor and my fellow classmates. I am Lin Chu-eun. My metric number is 27903. I'm glad to have an opportunity to present about the issues and hear about the Barcelona company, which between Belgium and Spain. The issues that we found related with the public international law is whether the claim of Spain is valid and under public international law. So the answer will be yes. In this case, it was argued about the Barcelona company's claim, which has incorporated in Canada but business operated in Spain. There was a lawsuit for Belgium to Spain for compensations to their shareholder as an action in protecting its nationals and interests. Since in the general principle of international law, Spain was able to decide to provide diplomatic protections for the Barcelona company. But at last, Spain did not do so. That is because only the incorporated company has right to bring a suit again in its state. The party only can claim when there was a breach or erga omnes obligations in international law. Therefore, Spain was valid and under international law. Besides, the hearing decisions had made by ICJ that proceeded with the judgment in 1917. Spain had raised 4 preliminary objections regarding the complaints from Belgium. However, ICJ rejected the first and second objections about the court's jurisdictions, and third and fourth objections ruled on merits to resolve the dispute, which Belgium had failed to gain diplomatic protections and damage claim from Spain. The court heard that international obligations, a government of a state should provide a foreign investment with legal, but it is not an absolute necessary neither. It means that Spain did not proceed international obligations to Belgium. And another one is about the diplomatic protections. It acknowledges that all states have legal interest in complying with such an obligations when with a specific case. The claim was only able to charge with 2 factors. The first one is a state has breached its obligations against another commitment of citizens. Second is the only opposition party to an international obligations can sue for breaches of duties. Therefore, the diplomatic protections had regarding the company nationality. The votes were 15-1. The majority agreed that Spain did not obligate Belgium. The court had judged that the lawsuit of Belgium to Spain was unsuccessful, that they had no right to claim for diplomatic protections and damage claims to Spain because the Barcelona company has cooperated in Canada.
The Barcelona Tractions case is one of the most significant importance and value in international law, particularly for the diplomatic protections and promoting the concept of erga omnes. The judgment recognized the concept erga omnes, a Latin expression meaning to all or to everyone. The legal sphere indicates that a court decision binds everyone, and that everyone has the rights and obligations. The 1970s judgments express the principle of the erga omnes, which is now regarded as a pillar of international law. It widened the international community's view. The concept of erga omnes is linked to the concept of just cogent, and established universal and superior norms of international law. For example, the 1969 Vienna Convention on the Law of Treaties established just cogence.
Now, let's take a look at our last case, which is the military and paramilitary activities in and against Nicaragua. The parties had involved in this case is Nicaragua and the United States.
The Sandinista Front, which known as Front Sandinista de Liberación Nacional, overthrew the government of President Somoza in July 1979. The new government was opposed by supporters of the former Somoza government and former members of the National Guard. The United States changed its positions on the new government when it discovered that Nicaragua was providing logistical support and weapons to the rebels in El Salvador. In April 1981, United States funding to Nicaragua was cut off. According to Nicaragua, the United States decided to plan and carry out anti-Nicaraguan activities in September 1981. The Nicaraguan Democratic Forces and the Alliance for Democratic Revolution were 2 of 7 groups that waged war against the new government. During the early age of the Nicaraguan conflict, The United States provided covert support to these anti-government groups, which known as the Contras. Later, the United States officially endorsed it. And the Contras were under the direct guidance of the United States. The strategy and tactics were designed and directed by the United States. The United States government financed and controlled the Contras, which were later disbanded. The overthrow of the Nicaraguan government was carried out by United States forces on the ground. Nicaragua's mining and other ports, oil bases, and naval base were all targeted in strikes against the country. The United States was then able to appear before the International Court of Justice during the merit phase after it declined to accept the jurisdiction of the court during the jurisdictional phase. However, the United States stated that when it requested the proportionate and necessary assistance to Costa Rica, Honduras, and El Salvador in response to Nicaragua's act of aggression against those countries, which rely on its inherent rights to collective self-defense under Article 51 of the United Nations Charter.
In this case, the issue is did the US violate the customary international law obligation not to intervene in the affairs of another state when it trained, armed, equipped, and financed the Contra forces, or when it encouraged, supported, and aided the military and parliamentary activities against Nicaragua?
So there will be yes. The jurisdictions or ICJ mentioned that the violations of the US in the customary international law has proved in Article 2(4) of the United Nations Charter that was all the members are restrained from involving through the use of force against another territory. The US used direct force in Nicaragua, such as attack of Nicaragua ports in 1983, and also assisted the contract force among 4 years that will be 1981 to 1984. The court regarded the lawsuit from the Nicaragua to the US as mainly on the mines in the Nicaragua port, not in the humanitarian aid for the contract force. And lastly, the main location has to be composed that the US breaches its obligations in international law to Nicaragua.
Nicaraguan military and paramilitary operations were the subjects of an International Court of Justice ruling on June 27, 1986. Concerning multilateral agreements, the ICJ was unable to make a judgment because the United States reservations and when it accepted the jurisdictions of the court. Thus, the court was forced to rely on the customary international law and general law principes to determine its decision. The relevant customary law norms had a lot in common with the treaty law rules that the court couldn't apply, that the force prohibitions in Article 2, Paragraph 4 of the United Nations Charter. The court was able to give specific examples of how treaty laws and customary law might coexist, and how the presence of the customary international law principes can be shown in broad terms. The court also addressed the additional rules of the customary international law in great depth.
In conclusion, international law is part of our law and must be ascertained and administered by the courts of justice of appropriate jurisdiction, as often as questions of right depending upon it are duly presented for their determination. As an important source of international law, international treaties and international customs are closely related and can complement each other and penetrate into each other, just as the cases of Pecati Havana, military and paramilitary activities in and against Nicaragua, and Barcelona Traction Light and Power Company in second phase that influenced subsequent court decisions that incorporated international law regarding other matters. These cases are also notable for citing a wide breadth of historical and international sources, including jurists from around the world and foreign state practices going back centuries.
That's all from us today. Thank you for lending us your ears.